hope you'll let us know. Let me stop there, and I may have time for one question. I don't know. Thank you very much.
Very cool presentation. Thank you, Dr. Overman. I think we're scheduled for a break right now, but before everybody rushes off, we'd like to recognize another platinum sponsor today, the North Plains Groundwater Conservation District. The North Plains Groundwater Conservation District is charged with conserving, protecting, and preserving the Ogallala Aquifer and the other water resources in the northern Texas Panhandle. The main district office is located in the city of Dumas in Moore County. The district issues water well permits, collects groundwater information, performs water quality analysis, and provides a number of well system tests and other services. Extensive databases are used to store, retrieve, and analyze groundwater information for the district. Let's give a round of applause for the North Plains Groundwater Conservation District. Thank you.
As an agricultural law specialist for Texas A&M AgriLife Extension Service since 2013. Her work focuses on legal issues impacting Texas landowners and agricultural producers, including leases, water law, oil and gas law, pipeline easement negotiation, and landowner liability. She travels the state speaking at various meetings and conferences on these issues. She also authors the award-winning Texas Agricultural Law blog, recognized as one of the top 100 legal blogs in the nation by the American Bar Association in 2014. She grew up on her family's farm and ranch in northeastern New Mexico between Tucumcari and Logan. Please welcome Tiffany Lashmet.
Well, thank y'all. I'm excited to be here today and have the opportunity to talk with you a little bit about groundwater law. I like to start off all of my presentations and tell you up front that although I am a lawyer, I pride myself much more on being a farm kid or a country person. So I brought a picture to illustrate that for you. We have there we go. This is my 2-year-old son. We took this photo over Christmas break. He went into our kitchen and he got an oven mitt out of the drawer. He pulled it up onto his arm and he preg-checked his stuffed cow. If that doesn't say we're country people, I just don't know what does. And we're happy to report she is bred and she got to stick around. I have to give a little disclaimer before I speak. I'm going to give you some general information today. I can't give you any specific legal advice. If you need that, you need to visit with your own attorney. So we're going to do just kind of an overview of Texas groundwater law today and hit on a couple of fairly recent cases that are important. So the basics of Texas groundwater law. Who owns the groundwater in Texas? We have somebody says the state, somebody says the landowners. So for Texas groundwater, it's owned by the landowners. So the landowner owns the water beneath his or her property. Now, I'm going to put one little asterisk on that. That's true unless the groundwater rights have been severed off. So just like we could sever oil and gas rights or mineral rights, you could also sever groundwater and have separate ownership. But absent something like that, the groundwater is owned by the landowner. It's governed by a legal concept called the rule of capture. And what the rule of capture basically says is, any landowner has the right to capture the groundwater beneath his property, regardless of if that harms his neighbor. And so this came about in a case back in 1901 called the East versus the Houston and Texas Central Railway. In that case, Mr. East was a property owner. He had some land. He had a well on it. I told him I wouldn't touch the mic, and I've done it 2 seconds in. He had a well on his property. Everything was good. Soon the railroad company moves in next door. They drill a bigger, deeper well. So what happens to Mr. East? His well goes dry, right? So being a good American, Mr. East goes to court and files a lawsuit. And his legal theory was fairly simple. I had a well, they came in, made my well go dry, that caused me damage, I should be able to recover for those damages. And back in the 1900s, the Texas Supreme Court said, not in Texas. In Texas, you have no remedy at law if your neighbor makes your well go dry. No remedy at law. So what's his remedy? What can Mr. East do? He can go drill a bigger, deeper well, right? And because of that, there are a lot of legal scholars around the country that refer to Texas groundwater law as the law of the biggest pump, all right? So that was reaffirmed, by the way, by the Texas Supreme Court in the Day case in 2012. And what the court said there was, yes, we follow the rule of capture. We are not going to take an invitation or an opportunity to change that. And additionally, landowners also own the water beneath their land as it's in place. So it's not that you own it once you produce it, but you have an ownership interest or a property right in that water still beneath the surface. That's going to be important when we talk about the Bragg case here in a few minutes, so keep that in mind. Now, there are a couple of legal limitations on the rule of capture. The first of those are a set of what are called common law exceptions. Common law means these came about in cases. They're judge-made laws. Frankly, these don't come up very often. I like to refer to them as the don't be a jerk rules, okay? They're things that are pretty common sense, like you can't drill a well if your sole purpose for doing it is to make your neighbor's well go dry. You can't wantonly or willfully waste water. You can't trespass or drill a slant well on your neighbor. These are pretty common sense, and like I say, we see very few cases dealing with those. The other sort of exception or limitation on that rule of capture is groundwater conservation districts. And of course, in Texas, the groundwater conservation districts have been deemed by the legislature to be the state's preferred method of groundwater management. And the idea there by the legislature was that instead of vesting groundwater management in a state agency in Austin or wherever, they thought we would be better off with local control. So what they did is they created this ability to have groundwater conservation districts subject to local control to manage groundwater withdrawals. So what do groundwater conservation districts do from a legal standpoint? Well, they have to require a permit for the drilling and operating of most wells. We're going to talk about some wells that are exempt from that permitting process in a minute. But generally, if you want to drill a well and you are in a groundwater conservation district, you've got to go get a permit to do so. When they're trying to make decisions on whether or not they're going to grant those permits, there's a number of factors that a district looks at. They look at impact on existing users, if the water will be put to beneficial use, how it comports with their plan. They also do planning out for the future to make sure we're going to have groundwater then, and what sort of waste and conservation plans does the potential user have. They also require that drillers' logs be kept and filed, and they may require records and reports of production from wells. They may regulate the spacing of wells or the production of groundwater. So you could have a spacing regulation or a limitation on how much groundwater someone could produce. And they may impose export fees for groundwater that's taken out of the district. So that's a little bit of what groundwater conservation districts do. Currently in Texas, there are 98 groundwater conservation districts and 4 that are pending confirmation. They cover all or part of about 174 counties. Keep in mind we have about 254 counties in Texas, so there are certainly some areas that do not have groundwater conservation districts. And they govern about 85% of our groundwater. Here's a map, and I realize that this is hard to see, but I think it'll still illustrate the point. On this map, you'll see every groundwater conservation district in Texas is in color. So anywhere that you see a color on the map, that's a groundwater conservation district. So if we look up in the Panhandle is a great example, the Panhandle Groundwater Conservation District, the High Plains, the North Plains, those are districts up here that cover multiple counties, all right? Some districts only cover one county, and we see those more down here in Central Texas. So districts are all different. We see the 102 different colors on the map. Those different colors also mean we have 102 different sets of rules governing groundwater production in Texas. And so that can make things pretty complicated. I know one rancher who owns a ranch here in the Panhandle, same ranch, even the same pasture, and part of it is in one district, part of it is in another. What he can do in one area is different than the other area on that ranch because the rules between the two districts are different. All right? Now, another point. On the map, you see the areas in white. And there are numerous areas where there's no color, right? There's a big block here and over here, some out here in the West Texas. All right? If you're a white area, that means you do not have a groundwater conservation district. And so there's no one that manages or regulates groundwater withdrawals in those areas. So those folks are subject only to those don't be a jerk rules that we talked about. They don't have groundwater conservation district rules that they have to follow. Now, I think that can be a little bit of a double-edged sword, right? Because when I hear, well, they don't have a groundwater conservation district, there's no rules that they follow. On the one hand, I kind of like that, right? As a country person, I think, well, yeah, I don't want anybody telling me what I have to do with my groundwater, right? But on the other hand, if nobody can tell me what to do, nobody can tell my neighbor what to do either. And there may be a situation where I want somebody bossing my neighbor around and stopping something they're wanting to do. And we have seen that some down in Central Texas regarding some pipeline projects. A couple of sessions ago, there was Hays County did not have a groundwater conservation district at the time. There was a group that came out, bought some property in Hays County and wanted to drill a well field. They were going to pump groundwater from the aquifer, pipeline it into Austin, and sell it to the city of Austin and some surrounding suburbs for water. In that situation, the Hays County residents were up in arms saying, hey, wait a minute, we don't want them to be able to pump our groundwater. And they ended up, a bill was put through the legislature to get them a groundwater conservation district. So like I say, keep in mind that there are things to think about on both sides of that issue. With regard to exempt wells, like I said, the general rule is if you're in a groundwater conservation district and you want to drill a well, you've got to get a permit from that district. However, there's a statewide statute in Chapter 36 of the Water Code that specifically says there are certain wells we're going to allow you to drill without making you get a permit. These are called exempt wells because they're exempt from the permitting process. So anywhere in Texas, if you want to drill one of these wells, you can do so without a permit. All right, the wells, this comes up most often for us, my work in agricultural law, is the first one. So if you want to drill a domestic or livestock well and you are on 10 acres or more, and you're going to put in a pump that will only produce 25,000 gallons a day or less, you don't have to get a permit. Okay? So domestic or livestock use, 10 acres or more, your pump will pump less than 25,000 gallons a day. If you meet those requirements anywhere in the state, you don't have to get a permit from your groundwater conservation district. Now, you may still have to comply with the other rules, right? Things like filing reports or driller's logs, things like that. But it's exempt from the permitting process. All right? Now, to further complicate this one more time, every district could make this exemption broader. All right? So they can't narrow it. This is the statewide kind of baseline, but a district could make the exemption broader. So, for example, I spoke down in Parker County a couple of weeks ago. They have an exemption that says any agricultural well is exempt and does not need a permit. Okay, clearly that's broader than the statewide exemption that only exempts livestock on 10 acres with a certain size pump. All right, so again, the basic thing to know with regard to groundwater law is, number one, you have to know if you're in a groundwater conservation district or not. Okay, if you are, you've got to go look at the rules of that district and see exactly what rules they have regarding permitting and things like that. Let's talk about a couple of cases. I think these do a good job of illustrating how some of these laws work in practice. The first case we're going to look at is one I mentioned previously, Bragg versus the Edwards Aquifer Authority. So this case came about down in Medina County. There was a pecan farmer named Mr. Bragg, and in the 80s, he planted 2 pecan orchards. All right? At that time, there was no body governing groundwater in that area. So since then, there has been the creation of the Edwards Aquifer Authority. It's not the same thing as a groundwater conservation district. Okay, they're created by 2 different statutes, so they're 2 different animals. But for our purposes, they sort of do the same thing. They manage groundwater withdrawals from the Edwards Aquifer, right? But in the 80s, when Mr. Bragg bought his land and planted his trees, that didn't exist. So at that time, he was basically in a white area on the map. He just planted his trees and irrigated them how he wanted to. Well, in 1996, the Edwards Aquifer Authority was created and went into effect. And what they did is they said if a person wants to irrigate out of the Edwards Aquifer or produce water of any kind, they have to come get a permit from us. And we're going to make our permitting decisions based on historic use. And so basically, if you could show historic use during a period, I think it was roughly 1973 to 1993, in that range. If you could show historic use in that period, you would get a permit. If you had not used Edwards water from that time, you wouldn't get a permit. Okay? So Mr. Bragg went in and he sought permits for each of his orchard. On one orchard, he was able to show some historic use, but he asked for double the amount of the historic use. And what he explained, at least in the lawsuit, what he said was the trees were bigger now and they needed more water. Okay? For the other orchard, he requested a permit, but he had no historic use because he had always irrigated that orchard out of a shallower aquifer that wasn't the Edwards. All right? So he goes, he requests these permits, and they're denied by the Edwards Aquifer Authority. On the orchard where he had historic use, they gave him half of what he asked for. So he got the historic use amount. On the other orchard, they just completely denied it and said, no, you can't pump Edwards water. If you're Mr. Bragg, you're probably not very happy about this decision, okay? And so he goes to court and he files a lawsuit. And his legal theory is really interesting. So when I talked earlier, I said the Day case made clear that a landowner has a private property right in the water beneath his land. So what Mr. Bragg's theory is that the Edwards Aquifer Authority is a state agency. The state is preventing him from utilizing his water in which he has a private property right. What has to happen under the Constitution if the state takes private property? They have to pay just compensation. And so Mr. Bragg's theory was this is a regulatory taking. The regulation, I am horrible at this. The regulations passed by the Edwards Aquifer Authority have resulted in a taking of my private property, and I am owed just compensation. It's an interesting legal claim, okay? One that we hadn't seen been successful yet in Texas. So Mr. Bragg files his lawsuit, and he wins at the appellate court. They say, yes, a taking occurred. He wins at the San Antonio Court of Appeals. And the Edwards Aquifer Authority appealed the case to the Texas Supreme Court, and they refused to take it. They denied the cert petition. So what that means is we are left with an opinion from the San Antonio Court of Appeals that says the denial of a groundwater permit, at least under these facts, constituted a taking of private property, and the landowner is entitled to just compensation. This was the first case that ever said that, so it's pretty important for landowners to be aware of. So what happened after that appellate court decision and the Supreme Court denied cert is the case went back to the trial court so a jury could determine what was just compensation. Well, what they did is they looked at the value of Mr. Bragg's property with all the water he asked for, okay? And they looked at the value of the property with the water he got. So basically, what the permits he was given / denied, what was the value of that land versus the value of the land with the full water he requested. He got the difference. So he gets the difference in property value between those two. And in this case, I forget the total number of acres. I'd have to go back and look. But in this case, that resulted in a verdict of $2.5 million for Mr. Bragg. Now, keep in mind, to get that, he got to pay a lawyer for 12 years. So, you win some, you lose some. All right. So again, this is a big decision in Texas because it's the first takings verdict with regard to groundwater. Now, I want to be very clear on this. Every time the Edwards Aquifer Authority or a groundwater conservation district denies a permit, you will not win a takings claim, okay? These claims are very difficult to win, and they're very fact-specific. The way a court analyzes these is under a test from the U.S. Supreme Court called Penn Central. And the court looks at 3 factors and conducts a balancing test. All right? So the first factor they look at is what was the investment-backed expectations of the landowner? That weighed in Mr. Bragg's favor, because when he bought that land and planted those trees, there was nobody managing groundwater. He had no reason to think the Edwards Aquifer Authority would come in one day and try to shut down his water pumping. Okay, that weighed in his favor. The second factor they look at is what would the economic detriment be to the landowner if he were denied this property right? He put in some evidence that was pretty good and showed that his trees could not make it without being irrigated. And so he could show an economic detriment. That weighed in his favor. The third factor that they look at is what was the interest of the state in regulating this area? In a water case, that's always going to weigh in the state's favor because, trying to manage groundwater and make sure that we conserve, et cetera, is always going to weigh in the state's favor. So the court looks at these facts, they balance it, and then they pick a winner. In this case, it worked for Mr. Bragg. In most cases, the landowner is not successful. But at least we have one on the books now in Texas where they are. So I think importance to be aware of. Another case we'll talk about is a little bit more recent and a little closer to home, the city of Lubbock versus the Coyote Lake Ranch. In that case, the ranch sold so this is a ranch out by Muleshoe, okay, cattle ranch in the sand country out there. Okay, in 1953, the ranch owners sold their groundwater rights to the city of Lubbock. So they negotiated with Lubbock. Lubbock made a payment to them and bought their groundwater rights. They executed a deed that said they had the rights to the groundwater, etc. All right? That happened in 1953. At that time, the city drilled a few wells on the property, but nothing major, and things went on. So over the next 50 years or 60 years, the ranch changed ownership. So somebody purchased the ranch knowing that the groundwater rights were severed and owned by the city of Lubbock, but they purchased the land and were raising cattle. Well, in 2012, the city of Lubbock comes knocking on the door and says, hey, we're here to drill the wells on your property that we're entitled to do under our deed. And they wanted to drill, I think it was something like 60 wells on the land. And this landowner wasn't very excited about that because how much money was he making from this? Zero, right? Because it was the guy before him that made the money. So this guy was going to get no money, and his bigger concern was they're going to really damage my property. If they drill these wells all over the place and they have to put in roads to get to them and gathering lines and things like that, they're going to tear up my property, they're going to tear up my forage. This is a big problem. So he goes to his attorney and he says, hey, come up with something. We got to have some sort of legal argument here. And they knew that the argument wasn't the city of Lubbock doesn't have the right to drill the wells because they pretty clearly did. They bought the rights to do that. So the argument they came up with is something from oil and gas law called the accommodation doctrine. What the accommodation doctrine says is if certain factors are met, an oil and gas producer or the mineral owner has to accommodate an existing surface use when they come to produce the minerals. Here's the kicker. This had never been applied to groundwater. It had only ever been used in the oil and gas context. So it was an interesting legal theory that we really didn't know how it was going to play out. So the landowner, they end up in court, and the Amarillo Court of Appeals sided with the city of Lubbock. And they said, hey, nobody has ever applied the accommodation doctrine anywhere but oil and gas. We're not doing it. And they literally said in the opinion, if the Texas Supreme Court wants to do this, they can, but we're not. So the landowner took the invitation and appealed to the Texas Supreme Court. And guess what? They did it. So the landowner goes to the Texas Supreme Court, and what the Supreme Court said was, yes, the accommodation doctrine can apply to groundwater just like it can apply to oil and gas. Okay, and we'll talk in a minute about how that plays out. The other big thing that the Texas Supreme Court said for the first time is that the groundwater estate, if severed off, is a dominant estate, just like oil and gas. That had never been said before. And what that does is that gives a severed groundwater owner some implied rights to use the surface of the land. In particular, what that means is, just like an oil and gas operator has the right to use as much of the surface as is reasonably necessary to produce oil and gas, now a severed groundwater owner has the right to use as much of the surface as is reasonably necessary to produce groundwater. So that was a huge verdict or a ruling out of the Texas Supreme Court. So the case now goes back to the trial court to see, we know the accommodation doctrine can apply to groundwater, but will it apply on these facts? Here's the three-part test for the accommodation doctrine. A landowner seeking to invoke this has to prove three things. The first is that there is a substantial impairment on an existing surface use. The second is that the mineral, or in this case the groundwater, can be produced another way. The third is that the surface use cannot be made in another way. So this came about in oil and gas, and the classic case was one from up here in the Panhandle. There were some brothers that had a center pivot circle of corn. They were not the mineral owners. The minerals were leased by an oil and gas company. They came in, guess where they wanted to drill their well? In the middle of the center pivot. Okay? And the brothers said, well, okay, we know you have the right to drill the well, but we need that pump jack to be less than 9 feet tall. Because if it's less than 9 feet tall, our center pivot can still go and we can irrigate our corn. Okay? And they had good evidence. They could show, number one, a substantial impact on an existing surface use. They showed that was the only feasible way to irrigate the corn. Number two, they showed that the mineral could be produced another way. They brought in evidence of short pump jacks, and they even found a guy down the road where the oil and gas company had a taller one, but he dug a hole and put the big pump jack in the hole so the sprinkler could go around it. Okay? The third piece of evidence that he had was that the surface use could not be conducted any other way. There was no other way to irrigate the corn. That case happened in 1948 and is the classic example of the accommodation doctrine. Anybody want to guess how many times a landowner's won since 1948 against an oil company? 0. So the accommodation doctrine exists. I'm not sure how super helpful it is. Will it apply in the city of Lubbock versus Coyote Lake Ranch? We'll see. They'll have to apply those factors to those facts. Okay? A couple of things I'm going to mention quickly as we wrap up. There are some federal groundwater issues you might want to keep an eye on, I think, that are very interesting. One of those is a decision out of California where the Ninth Circuit said that federal reserved water rights apply to groundwater. Essentially what that means is when the government sets aside federally owned land for things like Indian reservations or military bases, the Federal Reserve Water Rights Doctrine says they also set aside the amount of water necessary to accomplish the goal of that set-aside. We'd never had a federal court say if that applied to groundwater or if it was just surface water. The Ninth Circuit has recently said it does apply to groundwater. That could have some major effects across the West and is an interesting case. There's some issues, a couple of cases, one out in Hawaii and one in Kentucky. The question of if you have a Clean Water Act case where someone discharges a pollutant, okay, that would fall under the Clean Water Act, discharge of a pollutant, but they discharge it into groundwater and it goes through the groundwater into a water of the United States. So basically the groundwater is like the vehicle through which it travels to get to the water of the U.S. So in the case in California, they discharged stuff, I think it was from some sort of processing plant, into the groundwater, and it flowed out to the Pacific Ocean. Is that covered by the Clean Water Act? Because traditionally, groundwater is not covered by the Clean Water Act. But what if the groundwater is just the vehicle through which the pollutant travels? That's going to be an issue, and we've got a couple of cases we're reaching different results. Hawaii said yes, Clean Water Act applies. Kentucky, in a very similar case, said no. I think it's an interesting thing to keep an eye on. The last thing I'll mention real briefly is ownership of water rights on federal leased allotments in the West. We had a case in New Mexico, this was ruled on recently, that the folks who had the grazing leases on federal land actually had a water right. They owned the water right on that property, and we've seen lots of disputes on that throughout the West. The last couple of things I will mention very briefly. If you guys are interested in agricultural law or water law, I've got a blog where I post everything I write. So I write articles on all of these cases. I just did an article on the basics of Texas water law, both surface and groundwater. If you're interested, here is the website. It's agrilife.org/TexasAgLaw. You can go there and read those, and if you subscribe, a little box will pop up and ask if you want to do that. If you subscribe, you'll get all my posts sent to you just like an email from me. Okay? The last thing I'll mention, I've got a podcast, if y'all are into podcasts. It's basically like a radio show that's not on the radio. You can listen on your phone, on iTunes, or on the computer. That's the website right there. Every episode, I interview an ag lawyer about a different topic. So we've done one on waters of the United States. We've had Carlos Rubenstein came and spoke on surface water law, estate planning, immigration law, all kinds of stuff. So if you're interested, those are free. Check that out. The last thing I'll give you is my contact information. If anybody needs anything, has any questions, I'm more than happy to visit with you. I'm here at our district center in Amarillo, and I'd be more than happy to help however I can. With that, we probably have time.